Well, we have a new motion in the Castro v Las Vegas Metropolitan Police, etc. This is defendants' opposition to plaintiff's emergency motion to reconsider motion for preliminary injunction to stay state proceedings. Defendants Las Vegas Metropolitan Police Department, Officer Tony, Officer Bork, Officer Dingle, Officer Sorensen, Officer Sandoval, Officer Doolittle, by and through their attorneys of record, Marquis Urbach, hereby file an opposition to plaintiff's emergency motion to reconsider motion for preliminary injunction to stay state proceedings, ESC number 22. This opposition is made and based upon the attached memorandum of points and authorities, all papers and pleadings on file herein, and any oral argument permitted by the court during a hearing on this matter. Memorandum of Points and Authorities. Introduction. Plaintiff filed his emergency motion preliminary injunction to stay state proceedings on June 8, 2023, CECF number 18. On June 12, 2023, the court issued an order denying plaintiff's emergency motion for preliminary injunction, CECF number 19. The next day, plaintiff filed his emergency motion to reconsider motion for preliminary injunction to stay state proceedings, CECF number 22. The defendants now respond to the reconsideration motion. Federal law states that reconsideration is only permitted when there is substantially new evidence or the decision is clearly erroneous. It is well established that a motion for reconsideration may not be used to raise arguments or present evidence for the first time when they could reasonably have been raised earlier in the litigation. Case reference. Plaintiff has failed to articulate in his emergency motion to reconsider motion for preliminary injunction to stay state proceedings that there is substantially new evidence present that would require the court's reconsideration or that the court's decision was clearly erroneous. Instead, he merely reiterates the same arguments that have already been raised before the court and improperly mischaracterises the law to fit such arguments. Accordingly, the court should deny plaintiff's motion for reconsideration. 2. Statement of facts. A. Relevant facts and procedural history. This is a 42 USC 1983 lawsuit in which plaintiff alleges he was forcibly arrested while attempting to videotape a traffic stop, ECF number 2 at 1. Plaintiff's Nevada state law criminal charges are currently pending in Nevada State Court, ECF number 18 at 2. According to plaintiff, a preliminary hearing on the criminal charges was held on June 13, 2023. Prior to that hearing, plaintiff filed an emergency motion preliminary injunction asking this court to stay the Nevada state law criminal proceedings, ECF number 18. B. The court's order. The court issued its order denying plaintiff's motion for preliminary injunction on June 12, 2023, drawing on the Younger's abstention doctrine, which requires federal courts to abstain from interfering with state court criminal proceedings absent exceptional circumstances. Plaintiff's requested relief was to stay the June 13, 2023 hearing in state court, CECF number 19 at 1:14-15. At this point, plaintiff's first hearing in the state criminal proceeding is past, and yet it appears the plaintiff's ability to assert his constitutional rights remains intact. As this court has recognised in its order, plaintiff makes continuous, unsubstantiated claims that he will be subjected to excessive force and even death in a corrupt jail, which plaintiff claims would make it impossible to raise constitutional challenges in his state case. See ECF number 19 and 22 at 3:4-5. Specifically, the court notes that plaintiff gives no reason to suggest that he will be jailed or why excessive force will be used against him if he is. See ECF number 19 at 2:14-16. C. Plaintiff's motion for reconsideration. In plaintiff's current motion for reconsideration, plaintiff still fails to provide a sufficient basis as to why his constitutional rights would be chilled in state court or why he would be subjected to excessive force or even death if he were to be imprisoned. Instead, he continues to make conclusory statements that are not based on fact, but rather on plaintiff's assumptions. As such, his motion for reconsideration should be denied. 3. Legal argument. A. Legal standards. Federal Rule Civil Procedure 60(b) permits a district court to reconsider and amend a previous order. However, The rule offers an extraordinary remedy to be used sparingly in the interest of finality and conservation of judicial resources. And then there's a reference. A motion for reconsideration is not the proper vehicle for rehashing old arguments and is not intended to give an unhappy litigant one additional chance to sway the judge. Another reference. A motion for reconsideration should not be granted absent highly unusual circumstances. Another reference. Reconsideration is appropriate if the district court 1. Is presented with newly discovered evidence, 2. Committed clear error, or the initial decision was manifestly unjust, or 3. If there is an intervening change in controlling law. Another reference. B. Plaintiff fails to satisfy his burden under the reconsideration standard. This court's order denying plaintiff's motion recognised that federal courts should usually abstain from interfering with state court criminal proceedings, ECF number 19 at 1. In particular, courts should not act to restrain a criminal prosecution when the moving party has an adequate remedy at law and will not suffer irreparable injury if denied equitable relief. Younger. In other words, there should be no interference except where the danger of irreparable loss is both great and immediate. The standard to allow interference in a state criminal proceeding, because is stringent, no individual is immune from the good faith prosecution of his/her alleged criminal acts. Plaintiff's reconsideration motion includes the same arguments raised in its initial briefing and merely cited back to its original motion as the sole evidentiary support for the motion for reconsideration. It does not contain some valid reason why the court should reconsider its prior decision, or set forth facts or law of a strongly convincing nature to persuade the court to reverse its prior decision. Reference given. The reconsideration motion does not include newly discovered evidence, designation of clear error, or an intervening change in controlling law. Another reference. Here, plaintiff's entire motion relies exclusively on his prior arguments already made before this court. Additionally, plaintiff mistakes the law throughout his motion, specifically in response to the court's reasoning that plaintiff failed to provide a reason to suggest that he would be jailed. He responded by incorrectly stating that misdemeanors carry a maximum jail time of 6 months, as if that were the only consequence available to him. See ECF number 22 at 3-9-10. NRS 193.150 provides that 1. Every person convicted of a misdemeanor shall be punished by imprisonment in the county jail for not more than 6 months, or by a fine of not more than $1,000, or by both fine and imprisonment, unless the statute in force at the time of commission of such misdemeanor prescribed a different penalty. 2. In lieu of all or of part of the punishment which may be imposed pursuant to subsection 1, the convicted person may be sentenced to perform a fixed period of community service pursuant to the conditions prescribed in NRS 176.087. Thus, based on the plain reading of the statute, persons convicted of a misdemeanor shall be punished by imprisonment or by a fine of no more than $1,000, or a combination of both. Jail time for misdemeanors is not mandated by statute, as plaintiff implies in his motion. The state court could simply require plaintiff to pay a fine and not impose any jail time. Therefore, defendants agree with the court's initial determination when it concluded plaintiff has given no reason to suggest he will be jailed, because plaintiff has once again failed to adequately explain why he believes he will be required to serve jail time. C. Even if the court reconsiders plaintiff's motion, he has not shown that he will suffer irreparable harm to warrant the issuance of a preliminary injunction. In order for the court to issue a preliminary injunction, plaintiff must have shown he would suffer irreparable injury that is both great and immediate if such equitable relief is denied. Plaintiff has failed to articulate sufficient reasons why he would be unable to raise his constitutional claims in state court. Just like in Younger, where the court concluded the defendant was not entitled to equitable relief because the injury the defendant faced was solely incidental to criminal proceedings brought lawfully in good faith, the same argument could have been made here. Plaintiff's criminal proceedings in state court were not brought in bad faith or as a result of a series of repeated prosecutions against him. Furthermore, plaintiff hangs his entire argument on the fact that First Amendment rights would be chilled if the state criminal proceeding was not stayed. However, the Younger court itself stated that even a chilling effect does not by itself justify federal intervention. Then there's a reference. Moreover, that even the existence of a chilling effect in the area of First Amendment rights has never been considered a sufficient basis in and of itself for prohibiting state action. Idea 51. Therefore, even if the court decides to reconsider plaintiff's original motion for a preliminary injunction, he has not proven, beyond his own mere speculation, that he would suffer immediate irreparable harm in the absence of a preliminary injunction. In addition, plaintiff relies on a few cases to argue a preliminary injunction is not held to the Younger standard if charges have not yet been filed. See ECF number 22 at 2:15-17. Plaintiff further argues his criminal action is not pending and therefore his case should not be held to that standard. However, this is incorrect, as his case is pending in state court because he does have formal charges against him for 1. Obstructing a public officer under NRS 197.190 and 2. Resisting a public officer under NRS 199.280, which plaintiff himself has acknowledged. See ECF number 18 at 2:7-8. Consequently, this argument fails. 4. Conclusion. Based on the foregoing, LVMPD defendants respectively request the court denies plaintiff's emergency motion to reconsider motion for preliminary injunction to stay state proceedings dated this 20th of June 2023. And there you have it. I think that's going to be game, set and match on the injunction for the defendants. Thanks for watching.